Better Outcomes segment today being brought to you by mycdlp.com, mycdlp.com. Quitclaim versus warranty deed in divorce. That is the subject of our MyCDLP segment. Transferring ownership of real property incident to divorce. Most divorce professionals request a quitclaim deed when transferring property for a divorce scale. A basic understanding of the various real estate deeds, quitclaim versus warranty deed, is a must when transferring title and ownership to real estate during a divorce. A real estate deed is a legal document, almost always in writing, that passes an interest in real estate from one person to another. In short, when real estate is sold or given to someone, it is done with a deed. The new real estate owner receives their rights to the property and any title warranties transferred by the previous owner from the deed. The deed is the most formal type of private instrument. It requires an executing party, grantor, grantee, transferor, transferee, and witnesses as signatories and acknowledgments from a notary public. Therefore, a deed has a greater presumption of validity. Therefore, a deed has a greater presumption of validity and is less rebuttable than Therefore, a deed has greater presumption of validity and is less rebuttable than other types of real estate documents. The quitclaim deed is a legal document used to transfer interest in real estate from one person or entity, the grantor, to another, the grantee. Unlike other real estate deeds, it conveys only the grantor's interest at the time of the deed's execution. It does not guarantee that the grantor owns the property or has a good title. Without warranties, it offers the grantee little or no recourse against the seller if a problem with the title arises in the future. This lack of protection makes a quitclaim deed unsuitable when purchasing real estate from an unknown party. It is, however, a helpful instrument when conveying property from one family member or spouse to another, and it is commonly used in divorce proceedings or for estate planning purposes. Title companies may require a quitclaim deed to clear up what they consider a cloud on the title before issuing title insurance. Similarly, before funding a loan, lenders may ask someone who will not be on loan, such as a spouse, to complete and record a deed quitclaiming their interest. Real estate transfers between family members. Quitclaims are used to transfer property to and from family members, transfers between parents and children, between siblings, and between other closely related family members are quickly done with this type of deed. Adding or removing a spouse from title. Whether resulting from a divorce or a marriage, a real estate owner can use a quitclaim deed to add a spouse to or remove a spouse from the property's title. Transferring real estate to an LLC or corporation. With the holding of real estate in the protection of LLCs and corporations becoming more common, so are quitclaim deeds. Corporate transfers are usually done with this type of deed, as it is generally a transfer between closely related entities. Transferring real estate to a trust. As with corporate transfers of real estate, transfers to a trust are equally common. In addition, family planning deals with property meant to carry on through generations often involve an initial transfer from a family member into a trust. Removing a cloud on title for title insurance. In insuring title to real estate, companies may find a quote-unquote cloud in the title. Generally, this means that there appears someone may or may not have an interest in a property that has been accounted for, and it is causing a break in the chain of title. It is common for the company insuring the title to require the person in question to quitclaim their interest in the property before issuing the title insurance. Of all the real estate deeds, general warranty deeds provide the most protection to the grantee or the buyer. This type of deed guarantees that the grantor, the seller, holds clear title to a piece of real estate and has a right to sell it to the grantee. The guarantee is not limited to when the grantor owned the property, as with a special warranty deed. Rather, it extends back to its earliest title. As such, earlier grantors occasionally find themselves confronted by issues from future grantees. The grantors also guarantee that during their period of ownership, they did not encumber the property in a way prohibiting transfer. Incorporate express references to any easements, restrictions, or other agreements of record that relate to the specific parcel of land into the text of the deed. Providing this information puts the grantee on notice of the warranty's limitations and upholds the covenant against encumbrances. So the question is, should you use a quitclaim deed or a warranty deed when transferring ownership of real property in a divorce situation? Determining whether to use a quitclaim deed versus warranty deed will undoubtedly depend upon the individual case. However, having a thorough understanding of the risks and protections of each type should be discussed with your attorney. Divorce mortgage planning is a holistic approach to the process of evaluating mortgage options in the context of the overall financial objectives as they relate to divorcing situations. As a divorce mortgage planner, a CDLP, Certified Divorce Lending Professional, can help you identify any potential conflicts between the divorce settlement, financial planning, and home equity solutions, as well as any real property issues involved in your case. The role of the CDLP is to help integrate the mortgage selected into the overall long and short-term financial investment goals to help minimize taxes, minimize interest expense, and maximize cash flow. In addition, our goal is to help divorcing homeowners make more informed decisions regarding their home equity solutions and mortgage financing opportunities during and after the divorce. Incorporating divorce mortgage planning into the settlement process makes it easier to identify possible solutions and assists both parties in letting go of counterproductive positions and emotions. In addition, a CDLP can assist in taking stock of possibilities, resources, and answers regarding the marital home and other real property and mortgage financing opportunities. A successful divorce settlement results from effective communication and strategic negotiations in such a manner that both divorcing parties come out whole or at least on the road to recovery. Working together as a team and incorporating divorce mortgage planning into the settlement cycle with a certified divorce lending professional will ultimately result in a better solution and better outcome for the divorcing couple. Involving a certified divorce lending professional early in the divorce settlement process can help the divorcing homeowners set the stage for successful mortgage financing in the future. That is the Better Outcome segment brought to you by mycdlp.com, mycdlp.com. And hey, get your free Divorce Your Mortgage workbook at mydymworkbook.com, mydymworkbook.com.